My mission is to provide clients with legal solutions for preserving independence over their long-term health and financial needs. My purpose is to enlighten you today. Estate planning God's way. What is it? What do I need to do? And that last question is a very personal, individualized answer. No two clients are ever the same. As long as I've been doing this, I've not prepared a trust or a will exactly the same. By the time you leave here, I hope to have answered these two questions. You will understand what estate planning is and how it is definitely beneficial to every person, since planning is much more than just a will and a trust. What is estate planning? It is a process that allows and enables you to control and protect your property while you are alive and well, enable someone else to take care of you and your loved ones if and when you can't, give what you want to whom you want, how you want, when you want, avoid delays, maintain privacy, all at the lowest possible overall cost to you and those you love. The estate planning process, and this is the process that I take to each client meeting that I have. I first want to educate my client on the different tools that are available, because like I said, no two individuals are alike, and there are various tools in the estate planning toolbox. One is a will. We're probably all familiar with wills, or we've at least heard wills. Wills, it's your last testament, basically. It's an instruction on what to do with your property, who gets what. It tells the judge, if your estate is large enough and you need to open probate, it tells the judge who should get my property. Probate retitles your property into the name of whoever is your beneficiary. There's also the trust. Trust is basically a contract. It's an agreement between you, your estate, and your trustees. Now, while you're still alive, you are the trustee unless you want someone else to be your trustee. But then you have a trustee for disability, and you have a death trustee. There's also different kinds of trusts. There's special needs trust and supplemental needs trust. And those are trusts that, let's say that one of your loved ones is receiving a governmental benefit. And you know governmental benefits are based on your needs. And if your loved one inherited a large sum of money, they may get kicked off the governmental benefits. So the special needs or the supplemental needs trust is to enable you to pass on your wealth and your legacy, without harming your loved one. There's also, my favorite is the irrevocable life insurance trust. And as you know, life insurance is not taxed as income tax. However, it is added into your overall estate value. And right now, if you have an estate value that is $5 million for a single person, it's not taxable, but we're getting ready to go off that financial cliff, and the thing is that they may reduce the estate tax to $1 million. And if you own a home, you're pretty close to the $1 million. So the irrevocable life insurance takes life insurance out of your whole value of your trust, and so you won't get taxed either estate or income tax for your insurance. The trust also is besides your money and your retirement, your CD. Trust also contains all of your things. If you have, like my mom had a doll collection, it included the doll collection. It includes all your stuff, and you can then leave instructions so that your legacy, because you're much more than just money, that your legacy can carry on. You can leave a trust distribution tied to certain things, like 25%. If you really want your kids or your loved ones to get a college education, you can say, well, 25% when you graduate from college or a trade school, 25%, let's say that you love volunteering for the mission department. Well, you can get 25% of your inheritance after you've done 100 hours of mission work. Or you want to reward your kids for getting married, 25% when you get married, 25% when you turn 40. I mean, the sky is really the limit on how you can design your trust distributions. But one thing that I like to focus on is what's important to you, what's your morals, your values, your belief system that you want to leave to your family after you're gone. Another tool is the healthcare power of attorney. And healthcare power of attorney is basically giving the instructions to your agent if you cannot speak for yourself in regards to healthcare matters. Another tool is a living will or advanced healthcare directive. This is a wonderful tool because it provides clear directions and instructions on what your loved one needs to do when we're approaching the end of life. It basically tells them how and when to remove life support if that is an issue. We all remember Terry Schreiber. Her parents kept her alive for years and years and years and years. Well, she was in a permanent vegetated state, and now we just, this week, Hector Macho Camacho, what his parents, his mom had to, go to the hospital and give those instructions to, terminate her son's life. And those are very difficult decisions for your loved ones to make, but you can make it for yourself. And then we can't forget Sherman Hensley, AKA George Jefferson. He just got buried this week, and he died in July. So another estate planning tool is the durable power of attorney, and that's, again, if you can't speak for yourself financially, you leave instructions for your agent how to, pay your bills, give them authorization to go get your paycheck or your disability check, etc. There are very many tools that we can use. And then our next step, after I educate my client, we discuss the design, because like I said, no two estate plans are alike. We discuss their designs based on their individual needs. Like I said before, you can tie all your distributions to certain things, your values, your belief system. And then documentation is I actually do the estate. I prepare the documents, and then the implementation. If you have a trust-based plan, implementation is actually funding your trust, because your trust it's nothing unless it has assets in it. And then regular reexamination, because people's lives change, laws change, etc. So I recommend that every 18 to 36 months you think about your trust, okay? Did I add any family member? Did I lose any family member? Did I get married? Did I get divorced? Etc. So regular reexamination is important. And me as an attorney, my job is to stay current with the law. And if the law changes and it changes such that it is detrimental to my client's trust and their desires, then it's my job to contact my clients and let them know that you may need to come into the office because the law changed in a certain way. What is usually in an estate? Cash, savings, CDs, stocks, bonds, mutual funds, life insurance, retirement plans, homes, vehicles, boats, planes, investment and rental properties, businesses, jewelry, furniture, tools, antiques, essentially all of your stuff. Who is in my estate? Your family, your friends, your church, your charity, and even your pets. I recently had to do a pet trust. What are the objectives of estate planning God's way? To be good stewards of our wealth in the exercise of our God-given dominion over creation, Genesis 1:28. God blessed them and said to them, "Be fruitful and increase in number, fill the earth and subdue it, rule over the fish in the sea and the birds in the sky and over every living creature that moves on the ground." To provide a means of giving to others in need, Proverbs 31:9. Speak up and judge fairly, defend the rights of the poor and needy. To leave an inheritance for our children and grandchildren. A good person leaves an inheritance for their children's children, but a sinner's wealth is stored up for the righteous, Proverbs 13:22. And this passage really hit home to me when my grandfather died years ago, and I really understand what the word is saying to us, what we should do after he died. How can we plan God's way? By recognizing God as owner of all property, by thinking and acting as good stewards, by enabling our minor children to be raised and encouraged in their Christian faith. You remember how I said we can tie our distributions to our value system. By distributing property entrusted to us to those who will continue to use it to promote biblical principles and lifestyles. What is our biblical perspective for estate planning? We will give it all away, Psalms 49:16 through 17. Do not be overawed when others grow rich, when the splendor of their houses increase, for they will take nothing with them when they die. Their splendor will not descend with them. Only three choices: family, charity, or taxes. We will give an account, 2 Corinthians 5:10, for we must all appear before the judgment seat of Christ, so that each of us may receive what is due us for the things done while in the body, whether good or bad. We are called to invest time, talent, and treasure in building his kingdom, Luke 12:16 through 21. And he spake a parable unto them, saying, the ground of a certain rich man brought forth plentiful. And he thought within himself, saying, what shall I do? Because I have no room where to bestow my fruits. And he said, this is what I'll do. I will pull down my barns and build greater, and there will I bestow all my fruits and my goods. And I will say to my soul, soul, thou hast much goods laid up for many years. Take thine ease, eat, drink, and be merry. But God said unto him, thou fool, this night thou soul shall be required of thee. Then whose shall those things be which thou hast provided? So is he that layeth up treasure for himself and is not rich toward God. Critical questions. Does your family know what to do, when to do it, how to pay for it? And even if they do know that, are they properly authorized to do it for you? Common estate planning mistakes. Mistake, I'll take care of this tomorrow. Problems, you can't predict when disability or death will occur. Health usually gets worse, not better, more likely to become disabled than to die early. Your delay only creates someone else's stress or emergency. This is the probability chart that I got based on 2001 census. Probability of a disability that will last more than 90 days before you reach the age of 65. And looks like females, we will most likely be disabled and live past 65. That's basically what that chart is saying. Solution, I'll take care of this today. While you are able and helpful, face up to what you have and why you have it, remarriage and wrong time death scenarios, issues with children, naming executors, trustees, agents, and guardians. Intestacy. Intestacy is when you die without a will or a trust. And the courts will use the law of the land, whatever state, each state has different laws. James Dean died at age 29 without a will. His entire estate, including licensing fees, passed to his father, who abandoned him as a child. Licensing fees generate $1 to $3 million annually. Mistake, I have a will, so my estate plan is in order. Problem, it may be too simple, not accounting for changes in perspectives, circumstances, people, and law. Solution, update your estate plan often. You may need to add, delete, or change certain provisions. You may prefer a trust-based plan instead of a will-based plan. Unintended heirs. Marilyn Monroe, she died at age 36. She left 75% to her acting coach, Lee Strasberg, with wishes to donate to charity. Strasberg later married, and at death in 1982, his estate plus all of Marilyn's licensee and royalty fees went to his widow, a complete stranger to Marilyn, and not to a charity. Licensing fees generate over $1 million annually. Mistake, my family will make financial and health care decisions for me. And like I said earlier, how it was really personal to me, I'll interject some of my personal experiences. Problem, disagreement among family members, even if they're all doctors and lawyers. Solution, execute ancillary documents. Those are the living wills, the healthcare power of attorneys, the general power of attorneys. Name level-headed decision makers. Might not be a spouse, parents, or siblings. Should have successors. Powers can be limited or broad. Intentions can be stated in detail. I was the healthcare agent for my mother. When it was time to give that do not resuscitate order, although it was difficult, it was her wishes. And because she had given those orders, it empowered me. You know, I was able to tell the doctor, do not resuscitate. And she had 9 kids, and if she had not given those instructions, she may have been another Terry Schreiber. We could have argued. It was a gift that she gave us because we all came together and we made that decision, and we were in harmony. And like I said, it was a priceless gift that she gave us. I'm leaving everything to my spouse. Who needs a fancy will? Problems, just to name a few. Possible remarriage of surviving spouse, loss of predator or creditor protection, failure to provide for children versus stepchildren. Solutions, consider leaving property in a trust even for your spouse. Specific bequests, including trust provisions for particular children, your church, and other beneficiaries. Like I said, it is personal. My mom, like I told you earlier, she had this extensive doll collection. And had she not left that doll collection in her trust, maybe 1 or maybe 2 of her daughters would have, or sons, would have taken the whole collection. But she left specific instructions in her trust on how to distribute even her doll collection. And so every one of her female descendants, including her daughter-in-laws and granddaughter-in-laws, received one of her dolls. So her great-granddaughter, who only met her briefly, will have a piece of her as she ages. Mistake, I'm leaving everything outright to my children. Ooh. Problems, just to name a few. Bonded guardianship until age 18. If you have a minor child, and the guardianship under the law, if the court appoints, they may have to put up a bond in order to raise your kids. In California and most states, children are adults at 18. Now, what would you have done with a bunch of money at the age of 18? Ooh. Macy's, here I come. Instability of an early marriage. Now, these are real problems. Someone who was very, very dear to me, she died and she had a lot of stuff. She accumulated a lot of wealth. She had 8 kids and she died without a will or a trust. And so her estate had to be probated, and it took 4 years to probate her estate. And, you know, just think about the family going through that process every time. It's like pulling a Band-Aid out. You know, how do you heal? How do you grieve and go through all the stages of grief when you're stuck going to court all the time? But nevertheless, her estate was finally probated, and her kids, they got a lot of money. She had 2 daughters and 6 sons, and one daughter, she had a son who is a producer, and she gave 70% of her money to that producer's son, and in 6 weeks that was all gone. When her other daughter, she lives in a non-community property state, and she used her money to pay off the condo that she and her husband were living in. Unfortunately, the condo is not deeded in her name as well, and her husband refuses to put her name on the deed. And another one of her children bought a house, which was good, in the height of, you know, the real estate market. And now his house is upside down, and he's going to let it go back to the bank, and there's her hard-earned money. Solutions: leave property in a trust. It reduces the chance of blowing inheritance. There's different ways you can leave it: common, separate, sprinkling provisions. Does anyone know how long it takes for someone to get his inheritance check, and I'm sorry I'm using his inheritance check, and then go to a luxury car dealership? How long does it take? It takes an average of 72 hours. All your hard-earned money gone. Predators: spendthrifting. The Woolworth misfortune: Barbara Hutton and F.W. Woolworth. Granddaughter of Woolworth's founder. At age 10, she inherited $25 million. Her trust ended when she turned 21 in 1933, and it was worth $50 million. 46 years and 7 husbands later, she died at age 66 with a mere $3,000. Years of relentless exploitation, spousal abuse, drug addiction, and outrageous uncontrolled spending. Do no harm. I not only ask, will my fortune be safe with my children? I also ask, will my children be safe with my fortune? Andrew Carnegie. Wealth is like a blazing fire. It can warm and cook, or it can burn and destroy. The imminent dangers of excess access to unearned wealth are very real and very serious. Consider Jack Whitaker, the 2002 Powerball winner. He won $314.9 million in 2002. If you Google him, you will learn how he was one of the unluckiest lottery winners. Do some good. Endeavor to leave behind to kids who are content whatever the circumstances. If we produce kids who are productive and content, and this has been tried and tested, it almost doesn't matter how much we leave them. If we leave children who are consumptive and discontent, we won't be able to leave them enough. How much is enough for financial capital? I want to give my children enough that they feel like they can do anything, but not so much that they choose to do nothing. Warren Buffett. Yes. Sprinkling is when I had said how you can say, I'm going to give it to him at 40, at if he does this. That's sprinkling. Like I'm just sprinkling my money, leading him down the path that I want. Any other questions? Okay. Money is a tool to build spiritual and social capital into your children and grandchildren, and what is left is financial capital. God forbid one leave financial capital apart from social and spiritual capital. Money will never give wisdom, but wisdom may turn into money. Ron Blow. How much is enough for spiritual capital? Do not store up for yourselves treasure on earth where moth and rust destroy and where the thieves break in and steal. But store up for yourselves treasures in heaven where moth and rust do not destroy and where thieves do not break in and steal. For where your treasure is, there your heart will be also. Matthew 6:19 through 21. When should you plan your estate? between today and when you're not mentally capable of doing it. And we don't know when this is going to happen, when the mental incapacity happens. And this timeline, it shows how the different documents take place. The living will occurs between a catastrophic illness or injury and death. That's the one that says that, pull the plug. The will actually doesn't take place until after death. The power of attorney for health care and durable power of attorney, those are the ones that tells people how to pay your bills and how to take care of your financial life. They take place between mental incapacity and death. Your revocable living trust takes place from the moment you sign it, and it goes on and on and on and on. And it goes on till 21 years after the last descendant of your paternal or maternal grandmother. So it lasts a long time. Advanced planning strategies, those are like the dynasty trusts, if you want to form a family bank trust or a LLC. Even wills can fall short of estate planning goals. They don't provide for your incapacity. Wills only take place at the time you die. They are ineffective for naming guardians while you're alive, but disabled. If you cannot take care of your kids, your will can't say, this is who I need to take care of them while I'm still alive. They must be filed with the clerk of the court at death and then be probated. They're not private. They're open to anyone's inspection. Probate at death. The legal process of paying a descendant's debts and retitling all of that person's individually owned assets into the names of the beneficiaries listed in a will or heirs determined by law. Problems with probate. It can be expensive, court and attorney's fees, bonds, and document costs. I'll give you a little example on what it will cost in Sacramento County. You want to help me out? Thank you. The probate law, the probate code says that an attorney and or a personal representative, if you have a will, this is what they get. They get a 4% for the first 100,000, 3% for the next 100,000, and 2% for the next 800,000, and so on and so on and so on. For a small estate, that could be pretty hefty. Now, let's say that you have an estate, and let's just use it really simple. You have a house that's worth $550,000. Write that down. $550,000 is your estate. That's all you have is the house. But you owe $500,000. So can you put $50,000 in parentheses for me? Okay. Now, you died without a will, or you died with a will, and it needs to be probated. So in Sacramento County, it's 4% for the first 100,000. So can you write $4,000 down? And it is 3% for the next 100,000. So can you write $3,000 down? And then it's 2% for the next 800,000. So can you write $7,000 down? Now that's a total of $14,000. That's in attorney's fees. A total of $14,000 for attorney's fees. The law also allows your personal representative to get that amount as well. So let's double that for $28,000. So $28,000 out of, you only have really $50,000, is how much? $22,000? That's all that would be left. Plus, and I won't even account the figures, but it costs $395 to open your probate. And then the court charges 0.5% for non-cash assets. So you would have to pay on top of that, plus to sell the house. So it will be pretty hefty. Now, if you have that same house in a trust, it's already titled into the trust name. You don't have to go to court. And when you pass away and it goes to your beneficiaries, they get the $50,000 less cost to have a real estate agent put it on the market. So that's a big difference between probating and non-probating. And unfortunately, our community has been probating. Yes.
In addition to what you're saying there, if you own property out of state, then you go through probate in another state as well.
Exactly, unless you have a trust. Unless that property is titled into the trust name. That's correct. Good question. Thank you. Thank you. Probate is also time consuming. Like I told you that a good lady that I know, her estate took 4 years to probate. And then there's reports that need to be done and audits and all sorts of things. And probate is public. You know, they have predators going through the probate courts looking to see who's got what. So they can, you know, try and get money they didn't earn. So assets and distributions, they know, everybody will know what you have. Provisions of the will and testimony trust are open to the public. So lack of control, sales may be required by the court on the court's timetable. If you have a loved one that you want to stay in your house, the elderly parent or kids that you don't want the house sold right away, well, the court may not take that into consideration. So a trust, you can say, you know, don't sell the house for 2 years or so on, or ever. Probate while living. Probate while living is you become incapacitated mentally or physically, and you need someone else to take care of your finances and your medical treatment. And if you don't have a trust or the ancillary documents that we'll discuss later, then the court will have to do it. They have to appoint a guardian of the person, controls over your affairs. A guardianship of the state controls the finances, or general guardianship, which controls both. And like I said earlier, it's likely we will become incapacitated prior to death. We are living a lot longer. Living probate equals loss of control. How to provide for incapacity and avoid the court system. Use a revocable living trust. Use a power of attorney that's effective when incapacity is determined. And in those documents, you can say, well, I want to use a doctor and my spouse, or a doctor and a child, or a confidant who can determine whether I'm incapacitated and they need to take over, you know, my affairs. Provide personal care guidelines. Have and register health care documents. Use standby guardianship and medical consents for minor children. How a trust works. As the trust maker, you're the trust maker. You decide what goes in there and the instructions on distribution. And while you're alive, you are the trustee, you are the beneficiary, you control everything. And you put property in to your trust by either retitling it to your trust or by naming the trust as a beneficiary to receive later. After you pass away, the trustee follows the instructions and manages the property. The beneficiary gets the property or use of it. You can just say, you can use my house for the rest of your life, but then once you pass away, my house goes to this person or that person. But gets the property or its use according to the instructions. The living trust is like a dresser drawer. The top part is you and it flows down. It plans for your incapacity. It plans for your loved ones. It allows privacy. It minimizes probate. And the reason why I say minimize and not totally avoid probate, because sometimes you may get something between death and, between buying it and the time you die, and you may not have put it into the trust. So it minimizes probate. It is difficult to contest. It provides for control and continuity. It reflects your hopes, dreams, and values. It is good in every state. It avoids out-of-state probate. Did I answer your question, Deacon Murray?
Yes.
Okay.
Yes, you did. The benefits to a trust are substantially more than just a will, living trust.
Absolutely.
Because it avoids, unless you get something and you don't keep your trust up to date.
Right.
You get something substantially before or after your trust, and then you may have to go to probate for that item only.
For that item only.
That item only.
Right.
But if everything is in there, you avoid probate.
And if that item is under, I think it's 125,000, you don't have to go, it's not a long process. It's a small probate estate.
Excuse me. Okay, I've had a trust since 1997. Should I be refreshing it or doing something with it?
Absolutely. I recommend 18 to 36. And has anything changed in your life since?
I beg your pardon?
Has anything changed in your life since?
Yes.
Exactly. And so as things change, we should change and update our trust. We should let our trust reflect our hopes, dreams, values. They may change. The people in our lives may change. So yes, I recommend every 18 to 36 months, you yourself think about your trust. Yes, Suzette.
Can all trusts be updated?
Ab-
Some trusts that you can't update?
The only one that you can't update is the irrevocable. Anything that says irrevocable, you can't. But if it says revocable, you can do whatever. You can end it. It's revocable until the time you die, and then it becomes irrevocable. Any other questions? So how can we make life and death better? Consider all your options. I'm going to give you a couple of scenarios. John and Jane Client, and I have their trust right there if you want to look at it. They're all their estate documents. John and Jane Client. John's a policeman for 38 years, married, 3 children. Wife, Jane, she doesn't want to tell her age. She's a mother, owns video store. They have 3 kids. Marcus, age 14, he's already decided to be a doctor. Carl, age 10, has already decided to be a soccer player. And Dylan, age 6, has decided to aggravate his brothers. John and Jane's assets. Their assets look pretty familiar, look similar to our assets. They have a home and personal property, automobile savings, etc. Totals $225,000. Right now, they have a will-based plan. John's will leaves everything to Jane, and Jane's will leaves everything to John. They can't name they can name a guardian, but nothing to the kids, Marcus, Carl, and Dylan. There's issues both ways. A better death plan, protection. The assets of John and Jane, they're titled to the trust, and when the first to die dies, the family trust is for the spouse and for the kids, and the trust is set up in such a way that Marcus, he gets to become that doctor. Carl gets to do the soccer, and hopefully Dylan will get a life. Thank you. Maria Kleintessa. She's a single mom, works in Jane's video store, and she's 28 years old. And she has 1 child, Jose, and he's autistic, so he's probably gonna need some governmental assistance. Again, her estate looks very similar to ours. This is her plan. She either has a simple will or she has none. And there's issues with it going to Jose. Like I said before, Jose may need some governmental benefits. If he got all of $107,000 immediately, the government's probably going to cut him off of governmental benefits. A better plan is that she has a living will and trust, and she sets up a special needs for trust for Jose for his life. And that what special needs trust could do in this instance is just pay for all his health, education, maintenance, and support that the government doesn't pay. Maybe he needs, somebody to live with him, for the rest of his life. That special needs trust could provide for that. The life insurance is going to be payable to the trust as a beneficiary, so it goes into the trust to help Jose. And the IRA, it's a weird tax law with IRAs, and IRAs, you pay estate taxes if your estate is in a taxable estate, and you also pay income tax. So because they consider it income. Nevertheless, if you have your IRA directed to a charity or older relative, then the charity doesn't pay any tax. And an older relative, depending on how how old they are, it could be paid over their life expectancy and reduce taxes that way. Custom build the right estate plan for you and your loved ones. And these are the plans that I'm offering for our seminar, Basic, Premium, and Legacy, and you have a copy of that in your packet. However, I did want to point out the health document emergency card because I haven't discussed any of those, but I think I've discussed basically all of the other options. We make sure your documents work. Your documents are your healthcare power of attorneys, the living will, and your HIPAA authorization. Those are the 3 documents I'm referring to when I talk about your documents work. And what happens is that I offer a membership to some of my clients to this DocuServe. I forward a signed healthcare power of attorney, HIPAA authorization, and your living will to this service. And as you can travel, internationally, it doesn't matter. If you are ill and you are admitted to a hospital, the hospital can have access to those important papers. How DocuBank works for you. Your card displays vital medical conditions and allergies for quick access by hospitals. You carry your card in your wallet and use provided alert stickers on your driver's license and/or health insurance card. You present your DocuBank card when you are admitted to the hospital. Hospital staff calls for a fax or goes online to obtain your healthcare directives and emergency information immediately. In 3 out of 4 cases, this information is not available when needed without DocuBank. The DocuBank Emergency Access Card provides 24/7, 365 internet and fax access, quick access to critical medical information, protection for your healthcare wishes, easy stress-free access for your family, avoidance of unwanted medical interventions, and its international access. We protect you and your family with DocuBank. Any questions? What to do now? Call me to make an appointment for your personal estate, or better yet, I have 12 appointments available that you can sign up right now today for. Thank you for coming. The end result, peace of mind, well done, my good and faithful service. Thank you so much.